Hello, everybody. Welcome to the virtual Amicus, and I'm Jay Ludha. And hope you all are fine, safe in your respective houses, and taking good care of yourselves. Uh, well, we are all in the middle of a pandemic, and we all are aware of the uncertainties surrounding the same. We don't know when this will go or this will ever go, but let's all be optimistic, and things will get better, hopefully. So, keeping all of this in mind, this is why I've chosen today's topic as the laws governing wills in India. Now, as we all are aware, wills, unfortunately, frankly speaking, people are very hesitant to talk about wills in India. They don't really like talking about it openly. They don't have open dialogues. They don't want to have conversations. And when people actually sit down to draft, they themselves draft. They don't even consult lawyers. They don't take advice from anybody. So one thing that every person needs to keep in mind before I start the discussion is that you need to consult your lawyer. You need to trust his legal acumen. He's the expert. He's the expert in this very domain. You need to engage him and make sure that your lawyer drafts your will. And I reiterate, your lawyer drafts your will. So let's come back to the topic and let's start. So, what is the first thing that comes to your mind when I say the word or the instrument will? Where is it defined? What is the governing law? Who drafts the will? Is it necessary or is it mandatory under the provisions of the act that a will has to be registered, or can a will not be registered and still have the same legal sanctity that it promises to have when it is registered? Now, who all are capable of making a will? How is the property devolved? So these are some of the questions that I will try to answer during the course of my presentation. So let me first start by defining the term will. So it's defined under Indian Succession Act, which is the governing law, and it is defined under Section 2H. And here it is defined as the will means the legal declaration of the intention of a testator with respect to his property which he desires to be carried into effect after his death. Now I'll pause here for a minute. So the key words used in the definition of will are legal declaration of the intention of a testator with respect to the property which he desires to be carried into effect after his death. Now, the first two keywords here are legal declaration, the other being intention of a testator. Now, what does the word testator mean? Testator means the person who is making the will. With respect to what? His property, which he desires to be carried into effect after his death. So death is a crucial event here, and this event is only carried into effect when the testator dies or the maker of the will dies. So I'll repeat the definition. It means the legal declaration. So basically, you are getting into effect, you're carrying into effect uh, your intention, which you are legally declaring with regard to the property of the testator, and thus it will be carried into effect after the death of the testator. With also the other definition being that it is made for disposition of property according to the wishes of the testator after death. Now, uh, there are certain question and answers that I've prepared. When a will takes effect? So it takes effect only after the death of the testator. Now, the crucial event here is death. It will come into effect. It will be executed only when the testator dies or after the death of the testator. Now, who can make a will? A person has to be a major above 18 years of age, and he has to be of sound mind. But there are certain exceptions to this, wherein a person with a disability, which includes impaired hearing or impaired vision or speech, they are also capable of making a will. Also, an insane person at a particular level or interval of sanity can, draft a will or prepare a will, which includes, and also it includes foreigners and convicts. Now, who cannot make a will? Who is disqualified from making a will? A person who is, number one, intoxicated or is ill to a level that it hampers his sense of comprehension. He's not able to understand at that moment when he's sitting down to make it. So, a person who is intoxicated or who's ill, and that hampers his concentration. So that these requirements disqualify a person from making a will. One thing very important to note here is that even the corporate bodies are disqualified from making wills. Now, the basic criteria for making wills is defined under Section 59 of the Indian Succession Act, that there has to be a testamentary capacity, sound disposing, a person has to be mindful of knowledge of the contents of the will, and obviously the will has to be free from undue influence, fraud, coercion. It need not be done forcefully. This is what coercion means. And making a will should be a voluntary act that a person sits down and does it himself without any of the ingredients, which I just referred, like it has to be free from undue influence, fraud, and coercion. Now, what are the conditions of making a valid will? What are the requirements that result in a will becoming valid? So, the testator should either assign or affix his mark. It could be even a thumb mark. The will which has to be or must be attested by at least two witnesses. So, two witnesses are mandatory. Witnesses must have seen the testator sign or affix his mark to the will. Uh, the witness ideally should not be a beneficiary under the will, and the witness can also be appointed as an executor under the will. Now, as far as the paper is concerned, there are questions that we encounter in ordinary course, wherein people ask us as should a will be prepared on a stamp paper or should it be prepared on a plain piece of paper? So a will can be prepared on a plain piece of paper. No stamp paper is required or mandatory, but it is always recommended to go for it. And the advantages of using a stamp paper are twofold. One, it becomes easier for the transmission of properties, and as well as the process becomes smoother. And number two, there is higher authenticity that is attached to the will when it is prepared or drafted on a stamp paper. Now, how is this procedure and where is this procedure carried out? How do you get it registered? Where can you get your will registered? Is a very important question. So it can be registered, or you can get it registered at the office of the sub-registrar. Okay, I repeat, sub-registrar. Now, I will not get into revocation of will, which is not very relevant here. And now I'll talk about what probate, letter of administration, and succession certificates are. So it's very important for any person to understand the difference between probate, letter of administration, and succession certificate. Now, when is a probate granted? So a probate is granted in case of a registered or unregistered will, which an executor, in which an executor has been appointed. So basically, probate means that a copy of the will, which is certified under the seal of the competent court of competent jurisdiction, which is holding the grant of administration to the estate of the testator, and it validates all intermediate acts of the executor. So the keywords used are that it is a copy of the will that is obtained or certified under the seal of the court of competent jurisdiction, holding the grant of administration to the estate of the testator, and it validates all intermediate acts of the executor. This is what a probate is about. Now, what is letter of administration? There is a huge difference. What is it? It is granted when the deceased has left both immovable and movable properties, but no will, when a will has been left without any appointment of a formal executor of the will, when the executor is deceased after proving the will, but before its administration, when the executor does not have the legal capacity, and when the executor dies before the testator and another executor is not appointed. So that is when a letter of administration is granted. As far as succession certificate is concerned, now what is succession certificate? Succession certificate pertains to movable properties that a deceased leaves behind, and it is granted when the deceased has left only movable properties. Now, there were certain key legal words that were used throughout. I'll just quickly skim through and revise all of them for you. What do you mean by the term intestate? So intestate is a person who dies without leaving behind a valid will. Now, there are laws governing intestate devolution of property, which I'll refer later on. So intestate is a person who dies without leaving behind a valid will. Who's a testator? Testator is a person who executes a will, who makes or executes a will. Now, who are executors? So executors are people whose name is mentioned as beneficiaries or division of assets. So we can have 4 executors, and but it's always better to have one executor in case one person passes away. Now, what is a probate? Probate is that legal document which is maintained by the executors after the death and giving them the authority to handle a person's assets. Similarly, an administrator is a person who deals with division of assets even when a will is not left behind. And codicil is a legal document which amends or adds to a will. So for the purposes of a codicil being valid, it has to be written executed the same way as the will it amends. Now, I did mention about intestate succession earlier. Now I'll talk about it. So unfortunately, we see that most people don't bother to make a will. They feel that it is not required, and we'll see subsequently over a period of time what to do with the properties that we have. And then there is a lot of litigation that is involved. There is property litigation. There are a lot of disputes that people get into, and so to prevent all of this and to find an amicable but legal legitimate solution to this, it's always better to go for it and have a proper drafted will. So there could be a number of reasons for an intestate succession. Let's not get into it, but there are different acts that govern or talk about intestate succession. Specifically, Indian Succession Act of 1925, the Hindu Succession Act of 1956, and there is a Shariat law, and etc. and etc. So in ordinary cases, especially in the case of male Hindus, which includes Sikhs, Buddhists, and Jains, it devolves as per the schedules of classes that are mentioned under the mandate of the Act, which are class 1. And suppose there are no relatives in class 1, then it would devolve on class 2, etc. and etc. So I think that would pretty much sum it up, and hope uh, hope it was a good learning experience for all of you. Hope you've got a good hang as to what a will is all about. And I wish to reiterate what I said at the beginning of this presentation, that it's always better to consult your lawyer, trust his legal acumen, trust his wisdom. Always engage a lawyer to draft your will. It is very important. It has to be absolutely pinpoint and done accurately. There has to be accuracy, that it has to be done with a lot of precision, and it can only be done when there is a lawyer involved in the process of drafting and making the will. And thank you so much for watching, and please like, subscribe, share my channel, and most importantly, stay tuned, because episode number 2 is on its way. Thank you so much.